The Honourable Member for Calgary-Varsity.
Thank you, Mr. Speaker. It is with very great exuberance that I stand to address this motion 501, Amendment to the Constitution Act. And I'd like to start by thanking the Honourable Member from Lacombe-Ponoka for putting this motion forward. Mr. Speaker, the issue of property rights in Alberta is one that elicits a lot of attention. People feel passionate about it, and they approach it with great veracity. Because of this, Mr. Speaker, Alberta is the only province in Canada that's included property rights in our Bill of Rights through the Bill of Rights Act. And the Act enshrines, quote, the right of the individual to liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by the due process of law. Improving on property rights recognized under common law was a priority for Albertans, and this is why we are the only province to enact additional property rights legislation. Mr. Speaker, sometimes there are clear, necessary reasons as to why the Crown must expropriate land belonging to an Albertan, rural or urban, and in those cases it's of importance to provide a transparent process and fair and just value. These rules governing expropriation are laid out in our Expropriation Act, and if a landowner doesn't agree with the compensation or the reasons, then they are able to appeal the decision. As well, Mr. Speaker, the province's first property rights advocate, established in 2012, has a mandate to provide detailed, impartial advice to parties looking for independent information about their options. Cases can be settled by an impartial quasi-judicial land compensation board, or in some cases by the courts. Landowners are given opportunities to voice their opinions and objections and pursue fair value. Mr. Speaker, this government and every MLA in this room know what property rights mean to Albertans. And as a Calgary-based urban MLA, I must clearly state this is not just an issue for rural Albertans, nor is it an issue that only rural MLAs care about. As I've shared with this House before, Mr. Speaker, I grew up on a farm, a beef feedlot operation in southwestern Ontario. My parents, my siblings, and my extended family continue to farm in that area today, just as our grandparents had. As many honourable members know, for families like ours, a farm is not just a piece of land, a livelihood, or an economic asset. It's a legacy that passes down from one generation to the next, and it's a very real part of our family's history and our identity. While I was in law school many years ago, our family farm was expropriated by then Ontario Hydro to construct a 500 kV power line from the Bruce Peninsula to southern Ontario. Yes, there was consultation, access to courts, and ultimately fair compensation, but the impact of losing that barn with the family name on it still lingers. I share this with you, Mr. Speaker, so that honourable members here will understand that when I speak of property rights, it's not theoretical or legal. I'm speaking as someone who has lived through the experience of expropriation, as someone who understands the emotional value land has far beyond its value on a balance sheet. What I'm saying, Mr. Speaker, is that I care as much as any Albertan about the value of property rights. I care that landowners and property rights holders have effective notice, genuine consultation, and fair compensation. I know at a cellular level that expropriation of property should never be done lightly and only when it's absolutely necessary. But, Mr. Speaker, notwithstanding all those feelings and that experience, there are times when expropriation is essential for the benefit of all Albertans, and I must reject this motion on the basis that it would inappropriately distort that essential balance and would distort how these decisions were made here in Alberta. Mr. Speaker, I was in law school when the Canadian Charter of Rights and Freedoms was declared. In fact, I actually did a lot of research on Section 15, the Equality Clause. And as I recall with vivid clarity, the Canadian Charter of Rights and Freedom purposefully omitted any mention of property rights. Why is that, Mr. Speaker? Part of the reason is because authority for property rights was given to the provinces in the Constitution Act in 1867, as my colleague from Calgary, McKay-Nose Hill, has already pointed out, giving authority for property rights to the provinces was part of the system of checks and balances between the provinces and the federal government, upon which our country was created. If that power and authority over property rights was to be handed over by Albertans to the federal government and enshrined in our Constitution, this decision would not only be difficult, it would trigger outcomes that would not necessarily serve Albertans. Let's look at the process. First, a constitutional amendment requires adherence to a very specific process. We would need 3 resolutions calling for the amendment: resolution of the House of Commons, resolution of the Senate, and a resolution of the Provincial Legislative Assembly. And before we could pass a resolution here as a Legislative Assembly, we'd need a referendum. To constitutionally enshrine property rights in the Canadian Charter of Rights and Freedoms is no simple matter. Significant issues would require thorough discussion by Albertans, and the practical consequences of such a decision would have to be fully understood. For example, Mr. Speaker, moving property rights into the Charter would shift some aspects of decision-making with respect to Alberta's economic matters from elected officials to appointed judiciary. To many, that would simply be undemocratic. Most Albertans I know do not want property rights determined by judges. And Mr. Speaker, this isn't the first time this issue has raised its head in Canada. In 1972, who was concerned about the inclusion of property rights in our Constitution? Women's groups, Aboriginal groups, environmental organizations, and the provincial governments. A pretty fundamental list of stakeholders, Mr. Speaker. And then, as my colleague has mentioned, in the 1980s, the Lougheed and Getty governments from the province of Alberta opposed the constitutional entrenchment of property rights because of Albertans' concern about loss of provincial control, erosion of our property rights, judicial activism, and on the basis that the protections were already provided in our Alberta Bill of Rights. Mr. Speaker, Albertans command the respect of their government, and we are responsible to provide a government that can make responsive and timely decisions on issues most important to them. This motion is asking us to give up that mandate and capacity and offer it up instead to the federal government and to the courts. Mr. Speaker, giving up provincial authority and transferring power to the federal government, we would be failing the citizens of Alberta and future Albertans. We need to be able to work with Albertans in Alberta on the issues that matter to them most. Based on the implications for Albertans, we must deny this motion. Thank you, Mr. Speaker.